Mr. Sweeney, your client, Miss Cabrian, is here, and I saw you earlier. Thank you for coming back.
You're welcome, Your Honor. It was not of my own volition. The whims of technology have been throwing me back and forth a little bit this morning. I apologize if I cut out. I'll be making every effort to return if it happens again. We are prepared to proceed on Ms. Cabrian's matter. I believe she's present via Zoom. And Your Honor, this matter is before the court for confirmation. I expect that the state will be raising a motion to continue. I did receive notice of that motion to continue. I do have an extensive response and would request an opportunity to address the court prior to the court making a ruling.
All right. And Ms. Green, anything to add to your motion to continue?
No, Your Honor. Thank you.
All right, Mr. Sweeney.
Thank you, Your Honor. I understand the state's position in this. I also understand that Mr. Bretler's unavailability is unavoidable and that Ms. Green will be forced to kind of step into that role suddenly and abruptly. However, there are sort of two competing reasons why the defense, or I should say complementary reasons why the defense is objecting to this motion to continue. One is, Your Honor, this is alleged to be a no contact order violation case. This is a no contact order violation case in which the alleged victims are also the protected parties and are also the sole eyewitnesses as to the violation occurring. I will note for the court's information, defense has not been provided with a witness list, and it is defense's understanding that the alleged victims have reached out multiple times to the prosecution, indicating that they do not have information that is helpful to the prosecution, and they are uninterested in the case proceeding. I raise this, Your Honor. I understand this is somewhat putting the facts before the court in the inappropriate venue, but I do think it is important for the court's consideration of the prejudice that Ms. Cabrian is going to suffer as the result of a continuance in this matter. Ms. Cabrian is 39 years old. I understand somewhat gauche to raise her age. It is relevant because she is attempting to enroll in the Air Force. The Air Force has an age limit that restricts enrollment after the age of 39. She is going to be turning 40 on September 12th. She's been attempting to enroll in the Air Force for several months. As the court can see, this case has a significant pendency, and she has been attempting to enroll in the Air Force, I believe, for the last 6 months. Ms. Cabrian can correct me if I'm incorrect in that estimate. Is that correct, Ms. Cabrian?
Yes, I've been working with the recruiter since January, and he is waiting.
Yep. And Your Honor, the reason this is significant is because the recruiter requires all conditions to be cleared before Ms. Cabrian is eligible to submit the basic testing that's required for enrollment. Ms. Cabrian has provided multiple practice tests with passing scores. It's anticipated that she should pass. However, she's required to enroll in that test, provide a passing grade prior to her ability to actually enroll in basic training. Basic training would be likely to occur in either July or August. If this case is delayed significantly, if there's more continuances granted, it will not only affect the likelihood that Ms. Cabrian will reach that September deadline and be ineligible to proceed forward with her attempts to enroll in the military, which she's been attempting to do for some time now. It will also limit her ability at her recourse should she fail the test that she is required to complete. The interval of retakes on these tests is 1 month. As a result, she's already facing a disadvantage relative to other applicants and entrants because she has fewer potential retakes available already. And a continued delay really puts all her eggs in one basket for being able to pass this test. While I understand that the state might have an interest in making sure that they can put forward the strongest case possible, frankly, I just do not see that in this case where a witness list hasn't been filed, the alleged victims have been reaching out and making affirmative attempts to try to communicate with the prosecution, and it is a simple no contact order violation case, that the difficulties that Ms. Green will face in trying to be brought up to speed quickly at all outweigh the significant and extreme prejudice that Ms. Cabrian will face should she be unable to proceed forward with the career that she's been attempting to enter for the last several months. This is literally a last chance in Ms. Cabrian's lifetime opportunity that she'll be foregoing should this case continue to face unnecessary delays. So for those reasons, Your Honor, defense will be objecting to the motion to continue.
Thank you, Mr. Sweeney. That was very detailed. Ms. Green, one question for you. Is it just the absence of Mr. Brettler, the deputy prosecuting attorney assigned? That's the sole basis of the motion to continue, correct?
Yes, Your Honor.
All right, I'm going to deny the motion to continue based on the fact that I think the state can proceed on a violation of a protection order case without the assigned deputy. I think any deputy in your office should be able to prepare that case for trial. It's a not an assault for, it's not a difficult case. It's a violation of a protection order case. So I do think that it is unnecessary to continue this, and that any kind of delay in this would create a substantial hardship and would prejudice the defendant given the situation that has been outlined by Mr. Sweeney. So I would ask that your office get someone assigned to this case in lieu of Mr. Brettler and have this case prepared for trial, as I am going to allow it to proceed on the current docketed dates, which are June 12th and June 13th. Ms. Cabrian, your case will go to trial on June 12th unless you hear otherwise from your attorney or the state on this matter. That is in person, so that is not a virtual appearance. So please make arrangements to appear in court in person for trial on July 12th at 9 a.m. unless you hear from your attorney before that there's been some other resolution.
And just to confirm, Your Honor, that's June 12th, correct?
Did I say July?
Yes.
I am really getting the dates mixed up today. June 12th. Thank you, Mr. Sweeney.
No problem. I just wanted to make sure there wasn't any confusion. Thank you.